morning. My name is Dan Hartman. I am the president of the Cornell Federalist Society. Thank you all for coming. It's very proud. The first piece of information, you'll see that you have surveys at your desk. Please fill out the blue portion before the debate and the yellow portion after the debate. And I think it's pretty self-explanatory. And we're very, very pleased to have Leonard Leo here providing our introductions. Leonard Leo serves as the Executive Vice President and a member of the Board of the Federalist Society's national organization. In addition to his work with the Society, Mr. Leo has played an active role in both public diplomacy and politics. He was appointed by President George W. Bush, as well as the United States Senate. He served 3 terms, the U.S. Commission on International and Religious Freedom, where he served as chairman for 3 terms. He was a U.S. delegate to the UN Council and UN Commission on Human Rights, as well as the Organization of Security and Cooperation in Europe, and the World Health Assembly of the WHO. He also served as an observer at the World Intellectual Property Organization and as a member of the U.S. National Commission to UNESCO. While on leave from the Federalist Society, Mr. Leo organized the outside coalition efforts in support of the Roberts and Alito U.S. Supreme Court confirmations in 2005 and 2006. And in 2004, he was the Bush-Cheney presidential campaign's Catholic strategist. He also served as the national co-chairman of Catholic Outreach for the Republican National Committee. He's active in a number of Catholic organizations, serving as a founding board member of the Catholic Association, as chairman of the National Catholic Prayer Practice, and as a member of the Sovereign Military Order of Malta. Mr. Leo was the recipient of the 2009 Bradley Prize, along with other founders and directors of the Federal Society, for his work and efforts in advancing freedom and the rule of law through the organization. He is the co-editor of Presidential Leadership, Rating the Best and Worst in the White House, as well as the author of op-eds in the New York Times, Wall Street Journal, Washington Post, and other publications. Mr. Leo holds degrees from Cornell University and Cornell Law School, where he actually founded this chapter of the Federalist Society, and he's back for the first time in 5 years. After that, he presently resides in Northern Virginia, where he and his wife Sally have raised their 7 children. So please welcome back to Cornell, Leonard Leo.
Thank you very much, Dan. I feel very much at home because when I was going through law school between, I guess, 86 and 89, that whole new wing of the law school on the other side was under construction. So all I saw for 3 years was dust and dirt. And I'm glad to see you're having a similar experience. It does come to an end. It does do a lot of good for the school in terms of alumni relations. My class is probably the lowest kid in class in Cornell because of the construction that took place. But it's nice to see the institution grow. It's very good for that. It has been for years. First, I wanted to start by first of all, I know you have to fill out this form before the debate, so I will occupy some time when you fill that out. Feel free not to listen to me fill out the form. First, I want to express some gratitude for what the Federalist Society chapter does here at Cornell. Dialogues and exchanges that you're fostering here are very important. I just want to spend a minute. You know, the West often takes the rule of law for granted, and obviously it should. As Dan mentioned, over the past few years, I've had some experiences on the international front. I've probably in the last 5 years visited about 42 or 43 countries. And what I've noticed in visiting many of those countries which are located in Asia, North Africa, and the Middle East, is that the rule of law is extremely precarious state in many regimes around the world. It's a very fragile thing. And you see 2 different threads of threats, if you will, to the rule of law recently developing. One is governments like to take winners and losers. And that happens in a lot of regimes that I've visited, obviously in Africa, Asia, and the Middle East. And then secondly, you hear leaders in those countries also often saying, we face a crisis, which is often prefaced by them going ahead and ignoring whatever constitutional structure that exists in that country, whatever law normally is supposed to govern Now, this may sound slightly familiar to some of you, because I think we are hearing that refrain and seeing these two trends with increasing frequency in Western Europe, sometimes even in the United States, sometimes in Western Europe. And I think that that's something that manifests itself differently, certainly in the West, than it does in the developing world that we've seen it, but it's still very, very troubling. So I think there definitely needs to be a network, an organization, a distinguished, hard-working people who are thinking about this problem, who are being on watch for it, and who are working to bolster the rule of law by talking about how the structural constitution of our law advances freedom and dignity. And I think that the format we have today is precisely the way it should be done. Debate and dialogue. Because it's often very difficult to find truth. I think the best way to distill truth is to have a fulsome discussion like we're going to have today about what truth is. So thank you very much to this chapter for helping with that endeavor. And obviously the Federalist Society in Washington Now you're having a debate today, or an exchange today on Obamacare. And we've got two great people to tee up the subject and sort of hopefully start a discussion not only amongst themselves, but also you. So my task right now is to introduce our two speakers. First, Professor Tucker Culbertson. I've never met Professor Culbertson except for this afternoon. But I can tell you from his background that he is a very distinguished legal scholar. As some of you may know, because I suspect he did here before at other fora, he serves as a professor of law at Syracuse University's College of Law. He is also served as a fellow at Columbia's Study of Law and Culture, which is fairly well known in the academy. And what I found especially interesting about his CV was he's writing on all of the really sort of hot, cutting-edge issues right now. He's done a lot of work on counterterrorism, on the issue of marriage, the extraterritorial application of the U.S. Constitution, which has got a lot of attention right now. And of course, we have him here to talk about Obamacare, which the debate about which he's not into the court case in the last term. It was continuing with a number of other lawsuits on other aspects of Obamacare. So he has a very distinguished background in the area of constitutional law and jurisprudence, and it's a privilege to have him here today. If you happen to know the other speakers, Greg Katsas, a little bit better because we actually clerked together on the BC Circuit more years ago than I can count. I know a little bit about Greg's professional life as someone who's followed for many years, and someone who's been a friend. Greg, as some of you may know, took on the Obamacare case as a partner at the Washington, D.C. law firm Leonard. In fact, he argued one of the 3 days of that case, arguing the tax portion of the case. And I remember talking to Greg about his decision to do that, and the way in which he talked about the Obamacare case as an important inflection point in this nation's jurisprudential history regarding the rule of law and whether there are going to be appropriate limits on national power, and whether we are going to continue to have the structural constitution that is enforced. And I'm sure that will be subject to some debate this afternoon how far that structural constitution extends in the case of Obamacare and other laws that Congress may pass. Greg only had a distinguished career of public service and was still in the United States. In the Bush administration, and the civil division there as well. So possibly Greg has a lot of experience there. He clerked on the U.S. Supreme Court for Justice Clarence Thomas and has covered a number of the issues in his public as well as private life along the lines that Professor Culbertson has as well. So with further delay, I'm going to turn the program off to Oh, okay. The two of you, I assume you want to right?
Okay, sure. Okay. I thought I would try to do two things quickly, and Dan told me to try to be brief. I'll do my best. First is just give you my thoughts on the decision, and then the second is talk about some of the second-generation challenges to the Affordable Care Act. The decision, in my view, is in a couple ways very oddly schizophrenic. There are parts of it that are really wonderful from my side of the case, other parts of it that are really awful. And there's been a certain amount of debate of sort of who won and who lost. And while we obviously lost on the bottom line, there are people both on the right and on the left who think that we actually won some significant parts of it. Let me talk a little bit about that. First, you might say, well, we lost, so why might anyone think that we won? And the reason is, actually, the Supreme Court, in fact, struck down the statute that Congress enacted, which was a legal requirement to buy health insurance backed up by a penalty for noncompliance with that requirement. We set up a Commerce Clause challenge to that issue, and we framed it as the question whether Congress has authority to force people to buy unwanted goods and services. And the court took our framing of the question and answered it the way we had hoped and said no. And when you read the first 30 or so pages of the Chief Justice's controlling opinion, for our side, it's wonderful. It's everything we said. The power to regulate interstate commerce is not the power to force people into commerce. It's simply the power to prescribe the rules for people who voluntarily choose to be buyers and sellers. The historical argument that Congress had never before tried to do this. The precedential argument that even Wickard against Filburn, the most expansive Commerce Clause case, that's simply about regulating people who may not be engaged in commerce, but at least they're engaged in economic activity like producing and consuming the wheat on the family farm. Very different from forcing someone into commerce. The analogy of Wickard would be making the farmer's neighbor buy his wheat, and even the New Deal Congress didn't think they could do that. And finally, the consequential argument we made that if Congress can force people to buy health insurance, there's really no limiting principle, constitutionally enforceable limiting principle specific to health insurance, and the government's theory would allow purchase mandates for cars and mortgages and so on up to broccoli. And the court bought all of that, and we had a 5-4 majority for the proposition that neither the commerce power nor the necessary and proper power allow purchase mandates. That's not an easy case for us. Would have been, I think it's easy as an original matter, but given lots of modern doctrine, it would have been very easy for the chief to join the dissenters and say, look, we read the Commerce Clause broadly. The only thing that matters is impacts on commerce. There are large health insurance markets. People's decisions about health insurance have economic effects, and that's good enough for government work. He didn't do any of that. He strained to create this significant new Commerce Clause precedent for us. But then he flipped and, on the tax question, strained to reconstrue the statute into something that I think it pretty clearly is not. I said at the outset, they struck down the statute as Congress thought it was passing legal requirement to buy health insurance backed up by a penalty for noncompliance. The chief said that would be unconstitutional. So he recharacterizes the statute as there's no legal requirement to buy health insurance at all. There's simply a tax on being uninsured, and that's perfectly lawful decision not to have health insurance, but if you make that decision, you have to pay a tax. I think just about every indication in the statute is pretty clear. Congress thought that it was passing a requirement. All the language in the statute is mandatory requirement backed up by penalties. If you care about legislative history, pretty clear they didn't think they were passing a tax for political reasons. And the chief says, gee, this is not the better reading of the statute, but it's the one I'm going to adopt to save it. So the upshot is you can't force people to buy health insurance or cars or mortgages or broccoli, but you can tax them for not buying health insurance, cars, mortgages, and broccoli. And this is where I sort of, while I'm really happy and proud that we got this great Commerce Clause precedent, I actually think the tax holding really undoes the Commerce Clause precedent, because as we know, the power to tax is the power to destroy, and if Congress wants to force people to buy health insurance and they can't do it directly, well, now they can just impose a tax on being uninsured. There were certain checks on that before the decision was made. The most obvious was a political check. It's not popular to raise taxes, and there's a reason why Congress didn't structure this mandate as simply a tax on being uninsured, because there was no political will to pass a huge middle-class tax increase. That political check is now largely gone because the chief, in the name of avoidance, is willing to retroactively recharacterize something that really doesn't look like a tax and really wasn't sold as a tax. He's willing to retroactively recharacterize it in the name of avoidance to avoid a Commerce Clause problem. So not much of a political check if the politicians passing what is ultimately held to be a tax increase don't have to structure it or defend it that way. There was a secondary issue in the case about if it's a tax, is it a direct tax? There's a provision in the Constitution that has special protections for direct taxes. The line between direct taxes and indirect taxes is pretty fuzzy. The paradigm examples are that direct tax is a head tax, a tax on just existing. You're an American citizen, and by virtue of that, you have to pay a tax. The paradigm indirect tax is an excise tax, a tax on the transaction. And those are the easier taxes. Well, if you were worried about the government being able to extend its regulatory reach on people who are doing nothing, which is the driving force behind the chief's opinion on the Commerce Clause side of the case, I would think you'd be more willing to characterize the tax on doing nothing, on not buying good, as direct rather than indirect. And the chief says, well, the Constitution doesn't promise an immunity on taxes for doing nothing. That's true, but it would have been very easy for him to say, but it nonetheless, the tax on inactivity, while not prohibited, at least is a direct tax subject to requirements of apportionment and so on. But he didn't do that. He reads the direct tax clause very narrowly, so that confines it to basically the head tax and the wealth tax. So that is sort of gone as a check on Congress's ability to tax the failure to buy goods and services. And then the last possibility is there may be a substantive limit between taxes and penalties, depending on the amount of the exaction. And he says in the opinion, well, we can call this a tax because it's really not too high and people can make a fair choice not to remain uninsured. And if the amount of the exaction got higher, I may be willing to recharacterize the now tax back into a penalty because the amount is so high it's effectively punitive. The problem with that is it's been almost 100 years since the court has struck something that is formally a tax as a penalty based on either the amount or the punitive intent. So before we had the very broad modern Commerce Clause, you have cases involving like a marijuana tax or a sawed-off shotgun tax. And it's crystal clear that Congress is not involved. Congress doesn't really want to raise revenue from people using marijuana, they want to outlaw marijuana, and there was once upon a time a Commerce Clause question about that, so they passed this huge, obviously punitive tax. Court upholds it, says we're not going to second guess, we're not going to try to look behind the intent or the effect of the statute. If it's structured as a tax, we're not going to recharacterize it. If they're not willing to do that for the marijuana tax and the sawed-off shotgun tax, I doubt they will be willing to do it for a purchase mandate recharacterized as a tax, just because the amount of the exaction goes up. So I really, the bottom line for us is we got this great Commerce Clause precedent, and then we got this recharacterizing of penalties into taxes, and in my view, the second really undoes the first. And while there are lots of people across the spectrum who think that the Commerce Clause precedent is really something new and significant, I think the bottom line is it's just not going to have much bite for that reason. Let me just tell you a little bit about some second-generation challenges. I'll talk about three briefly. One is an origination clause challenge. Origination clause is a provision in the Constitution that says bills for the raising of revenue have to originate in the House of Representatives. Well, we now know that the mandate has been recharacterized as a tax. There are lots of other taxes in the statute. There's a pending origination clause challenge on the ground that the bill that became the Affordable Care Act didn't really originate in the House. It, for all intents and purposes, originated in the Senate. So what happened? The House passed a bill. The Senate took the House bill numbers, called the shell bill. They took the bill number, stripped out the actual bill, put into it the Senate bill. That bill passes the Senate. The Democrats then lose their filibuster-proof majority in the Senate. So instead of the ordinary course, which would be that becomes the Senate bill, the House then passes its own bill, and all the differences get worked out in conference. What actually happened was the only way there was going to be a statute was if the House literally passed nothing but the Senate bill. So that's the only way they could have avoided having to go to conference and being subject to a filibuster, and that's, of course, what happened. And the statute passed on that basis. And if you are sort of willing to look at substance over form, and that's a big if in this area, it really sort of looks like what happened was it was the Senate bill that was put up and ultimately passed. So that's pending. I'm not too optimistic about that. Some of the conservatives, Justice Scalia has suggested that origination clause challenges may be non-justiciable, and if he thinks that, hard to see how the challengers get to 5 on that issue, but that's one interesting case working its way through the courts. Another is a kind of dry, technical, statutory and administrative law question having to do with the subsidies. It's not the most sexy kind of issue, but it's a pretty serious case that, if successful, would do some pretty serious damage to the statute. So here's how it works. The scheme for the near universal coverage of Obamacare is people up to 133% of the poverty level get their health care through Medicaid. People in the large band between 133% and 400% of the poverty level, that's a lot of people, they get their coverage through health exchanges. And the statute has a whole section devoted to exchanges. It invites the states to set up their own exchanges, which are supposed to be these markets for providing health insurance to people within that band of income. And people in that band who buy insurance on an exchange get a big subsidy in the form of a tax credit. Well, the statute, it turns out, has this odd drafting feature that the exchanges are only available if the people in that income band purchase insurance on an exchange run by a state under a particular section of the statute. And the statute distinguishes pretty clearly between exchanges run by states and exchanges run by the federal government if the states choose not to. The structure is, I'm paraphrasing obviously, but Section 1, any state may run an exchange. Section 2, if any state doesn't run an exchange, the federal government will come in and do it. And the subsidy provision says subsidies are available for the people who buy insurance on an exchange run by a state under Section 1. So it turns out something like 20 to 25 states are not going to have exchanges up and running. There are going to be huge numbers of people who get their health insurance not through state-run exchanges, but through federally run exchanges under different sections of the statute. And there's, I think, a pretty serious open question whether the subsidies are available for that kind of insurance. The Treasury Department has passed a regulation saying, yes, that's subject to challenge. It'll get some measure of Chevron deference, but the courts will make their own judgment. If the challengers win, then there's basically no subsidies for insurance through the exchanges in maybe half the states. And it's even worse than that because the employer mandate, which is another mechanism for providing coverage through workplace insurance, the employer mandate, the penalty on the employers kicks in only if the employer has employees who, because they can't get insurance through their employer, get it on a state-run exchange, get the subsidy. Well, if there's no subsidy when that employer has to get the insurance from the federal government in a state that's not running an exchange, there's no penalty imposed on the employer for not providing the insurance, and so the employer mandate part of the statute falls apart as well. So that'll be interesting. I think that's the one pending case I know of that really has a significant possibility of unraveling major parts of the statute. The last thing I'll mention is, I think, maybe in some respects the most interesting and most serious of the challenges, which are the Religious Freedom Restoration Act challenges to mandates imposed on people that violate those people's religious beliefs. I don't think these challenges have the potential to really unravel the statute in any fundamental way. What they would do, if successful, is create rights of conscience for individual objectors who don't want to be forced to provide contraceptives or abortion services and such to employees or whoever. The Religious Freedom Restoration Act is an incredibly pro-religious liberty statute. It says that the government must make exceptions to all of its statutes for conduct that is religiously motivated. And it's been interpreted very much in favor of religious liberty. When I was in the government, I lost an in-bank case in the 10th Circuit that seemed to me pretty much an unlosable case, which was the question whether the government could apply federal drug laws to people using hallucinogenic drugs like LSD if they wanted to do that for religious reasons. I mean, my goodness, of course the government has a compelling interest in doing that. Well, the 10th Circuit went against us 8-5. I thought I must be a pretty bad lawyer for losing that case, except the Solicitor General's office took it up to the Supreme Court, and they lost 9-0. So that gives you a sense of how far this court is willing to go in protecting religious liberty. If the government can't apply drug laws with respect to the most dangerous Schedule I hallucinogens because an individual has a bona fide religious reason for wanting to use that drug, very hard for me to see how they could then force someone to provide abortion services or contraceptives in violation of an deeply held religious view. So those cases look like they're pretty strong to me. My firm is working on some of them, but I'm not involved, so that's just the thoughts of an interested observer. I've probably gone on too long, so let me just stop there and turn the floor over.
I want to say everything. I have 3,000 things I want to say. First, of course, I want to thank all three gentlemen who spoke before. I'm really pleased to be here. I have developed this very sort of regular and ongoing relationship with Federalist Society chapters at my home institution and kind of around the country, which has been a big surprise for all of us. It has. It's been a very big and delightful surprise. And I hope whatever it is I have to share today will be useful in the way that I've been useful to some chapters, which is just that I just am a general negative, contrarian, person with not much hope for civilized society. So I can be deeply disappointed in any left approaches, right approaches, and I don't see much value for me in trying to make an argument to you or anyone really about how these questions ought to be answered. But I do have a lot of questions. So to respond to a couple of things that have just been said, and of course I understand it's certainly a term of art, but to be perfectly clear, the conversation regarding religious exemptions from the requirements that involve contraception, we're in no way talking about requiring actual provision of services or provision directly of goods from employers to desiring employees. And I'll be coming back to the religious liberty cases, which are proliferating daily because the regulations are changing monthly. And I think they are very interesting. I think they're, in many ways, although I think I certainly agree about the actual likelihood of outcomes, I think the questions in those cases are absolutely central for our moment and our zeitgeist in U.S. constitutional law regarding corporate personhood, regarding rights holders, regarding the balance between a commitment to a certain kind of secular pluralism and a deep and genuine respect for those who are following simultaneously the laws of the state and nation and the laws of their God. And that's very important and very serious. And these are all hovering around these cases which may not end up being the landmark cases or the big victories that they might have been. They may not dismantle the Affordable Care Act. But pay attention to them anyway, because lying around inside of them are, I think, some of the most important questions that are coming up individually throughout our various constitutional squabbles. On the Affordable Care Act in general, as with other recent Supreme Court cases like Citizens United, what has struck me most in the responses after the opinion is a certain unwillingness, it seems to me, in popular discourse to address what the Congress might do, may do, could do, has done around the various disappointments in the Civilist opinion. We call it Obamacare, right? And rightly so. And Citizens United, we blame the court for ruining campaign finance. But I think there's a lot of conversation to be had around matters of policy and around matters of congressional labs, frankly, in the issue of the Affordable Care Act that I think falls to us. I think the rule of law is at issue in these cases, but so is, I think, the obligations and responsibilities of the people. And we all know that in the 10th Amendment, of course, after the powers are reserved to the states, they're left to the people. And I think our direct engagement in determining this quite apart from how it's settled in the courts, is crucial. We are not watching other people who are doing the work, and I just felt inclined, although it's been a little rambling, to stress that. I think that the old school Republican notion of getting to work and getting in the ears of those folks who are allegedly working for the good of and representing not simply a party or a left or a right, but a constituency, I think there's all kinds of important work that can be done there that won't show up in the courts. But we're here, so let's talk about what shows up in the courts. The religious liberty challenges for me are intellectually very interesting, and they're just personally very important. I'm real serious about Jesus. I'm a very serious. My life is organized around my religious beliefs. That's just the truth. And I take that very seriously, and I see inroads made against free exercise daily, monthly, in local, state, federal action. And it concerns me greatly. However, it's also just intellectually interesting because we know from the First Amendment that the two religion clauses create a complicated bind for themselves, right? We have two clauses. And if you get out of trouble with one, you may be in trouble with the other. And this is the perfect example. On the question of required coverage for contraceptive, abortive, or other reproductive technologies or services. The problem is that simply putting that out there with no exemptions for believers, right, for religious institutions, would compromise free exercise. Right? That's what you're guaranteed, the free exercise of religion. And that's why there are, of course, as in many laws, discrimination laws, etc., exemptions given for certain types of people and places, for religious institutions in employment. Here, what we have now with the regulations are exemptions not only for for houses of worship, but exempted from these requirements would be all nonprofit entities whose work and whose leadership suggests and leads to an opposition, a religious opposition to the use or provision of contraceptive or other materials. Right? So to not give them any exemption would compromise their free exercise. But once you give them the exemption, we may have an establishment clause problem. Insofar as we've singled out, and in our history we've singled out specific even denominations of faith, right, to exempt from certain otherwise applicable regulations. So what's interesting to me and what I'm invested in personally is how we skirt this, not just in solving this issue, but as a people, how do we understand this commitment in the religion clauses? On the one hand, to say the free exercise has to be allowed and defended, and on the other hand, we can't have the government privileging religion generally, or any particular religions, certainly. That's a tension that I don't think is simple to resolve. Where the challenges are now, which is just all I want to share about that, is initially, motions to dismiss were denied. We had a couple of advances. We now have some dismissals of these suits. But we've seen, since we got out of the civilist decision, we've seen a reanimation. And certainly since the early 2013 alteration to the exemptions around contraception, there's even more litigation. The tension is to ask whether, first, right, is it acceptable for the exemptions to apply to religious institutions and not just any employer or institution? Is that an acceptable distinction to make? right? A religious institution whose purpose it is to provide religious ministry and counseling. What if you're a believer who runs a convenience store? Why aren't you similarly compromised in your free exercise? Just because your job, just because your practice, where you spend the daytime or nighttime hours depending on when you work, should that dictate whether your free exercise is worthy of an exemption? It doesn't seem quite right. Well, then there's a further distinction. Well, okay, they said, all right. Not just houses of worship. Not just... Okay, any nonprofit that, again, is engaged in or whose leadership can assert that this would violate their free exercise. Well, but then we have to say, why nonprofits? What's the difference, again, between whether you're running a nonprofit university that has a religious affiliation or whether you're running a convenience store? I don't know that there is a difference for free exercise. The final distinction that's crucial, and this goes back to the double bind of the religion clauses, whatever exemptions get carved out, they will undoubtedly be carved out in response to those who have had the strength and commitment and resources to successfully, get these exemptions from the Congress and the administration. Well, that might be an establishment problem insofar as that it starts to seem like certain religious objections. Maybe, okay, here to contraception. Well, what about blood transfusion? What about maiming of body? What about all manner of other medical practices that offend others' forms of religious belief? We're very, very focused in on Catholic institutions and on the question of contraception, the question of abortion, and that is entirely appropriate. And it's just the beginning of the list to talk about compelled coverage for medical procedures and how that relates to individual employers' beliefs. The only way I think that one can get around that, and I offer this not genuinely, not as an argument, but I do think it's something worth considering, is to ask whether the free exercise right is a right that can inhere in institutions, right? Like Liberty University or like, the Southern Baptist Union and Caucus. Or is the free exercise right more specifically held by actual individual beings, right, subject to and in a relationship with the God or gods or other force according to whom they organize their lives? This is an argument that has been made in some of the recent lower court opinions in the dissents. It's to say, wait. I don't know that corporations even enjoy free exercise rights. Now, it hasn't mattered, right, because the interests of the corporation are the same as of the owners or the shareholders or whomever, and so whether through third-party standing or next friend, they've allowed it to go forward. But I think it's an important question. I think it's important not only because, as you all well know, folks are running around saying, the court told us corporations are people. What are they saying? And I find Citizens United objectionable in a million ways. But that's just not what they said. And it certainly wasn't the first time that corporations have been recognized as a person. A person is any subject of law that can be held accountable or that can claim an injury. It's very simple. But we've always made distinctions among persons, right? Citizens versus legal residents. Naturalized citizens versus birthright citizens. We've always made distinctions among persons as to what rights they enjoy and to what degree. The 14th Amendment makes it very clear. We have a clause about citizens, we have a clause about persons. We can carve distinctions around corporate persons, despite the fact that we've recognized that corporations are persons, and despite the fact that we've said, as regards the free speech clause and political expenditures for campaigns, they're identical to regular folks. We can say that there. I just don't know that we have to then say that corporations can claim an injury of their free exercise. I don't know that a corporate person can pray. or a corporate person can be penitent, or a corporate person can sin and suffer the consequence. I just don't know if that right can actually be enjoyed by the person that is incorporated. If that's the case, then I think that makes a bit of a problem for the free exercise plan. But it also leads to what I think is the more general, for me, jurisprudential and politically troubling and sort of vibrant issue, which is if we allow that sort of free exercise challenge to go forward, and if we say, no, there's not even an establishment clause problem in focusing in on contraception and reproductive technologies, which are indeed, forbidden and prohibited within many religious communities, but we don't worry about any of the rest of those, minority religious communities. Don't worry about them, right? If we can get through all that, there's another free exercise problem that I have real concerns about. And that's the free exercise of individual employees in religious institutions. My concern is this, and my question rather is this. If our value is on the genuinely free exercise of one's religion, meaning not just believing, not just practicing, but living in it, I think freedom to sin has to be a part of that. I think that the free exercise that's really truly at issue here for me is the free exercise that's impinged upon by any exemptions under this law. By any exemptions, because the free exercise of a believer to nonetheless access, without a special set-aside different insurance program, to access technologies or procedures that she definitely truly believes are wrong. I think that's got to be her choice and not that of the board or the shareholders or the owners. My point being that I think we can consider whether, with the exemptions, any corporation can properly exert free exercise of religion, or if that's just maybe different in kind. I don't think corporations can shoot guns. I don't know how that works with the Second Amendment, but they can be different. But then secondly, I think we ought to maybe extend our conversation about free exercise, not just to outside the corporate person, but to the employees. Not the employees who don't share the beliefs, precisely to those who do. Free exercise in the time of the founding is certainly just a synonymous euphemism for free will. And I think that has to allow, it seems to me, as a jurisprudential matter, for us to all have the choice of lapse without governmental imposition. And so I think those are, if not technically going to be legal issues and concerns for the courts going forward, I think they ought to be for our collective political and constitutional discourse, because I think it's being held and dominated right now largely by our executive branch and by certain well-meaning and very well-resourced religious institutions. But I think it's all of our conversations.
Throw it open for questions. Let's take questions.
All right, we'll open up to questions if anyone has any questions from Byron?
Yeah, actually, either of you could answer this, but I think that this would be a little more appropriately directed to you. So in the beginning, you said that Justice Roberts recharacterized the law as a tax, and that you won on the argument that the Commerce Clause wouldn't support a mandate.
Right.
So, but the problem, or at least, here's a question for you then. How much weight do you think the argument would hold that in fact the Commerce Clause holding doesn't have any precedential weight because he wasn't required to hold that in order to make the tax clause hold? In other words, it's just, even though he said, no, I have to hold this in order to get to this, that, later on somebody would say, no, actually, Roberts, this was taken out. I mean, it's kind of an academic question. I suppose.
It is an academic question because lower courts, virtually all lower courts are going to follow it. And if the Supreme Court gets this question in the future, it'll just depend if 5 of them like the holding, it'll be a holding, and if 5 of them don't like it, it'll be dicta. But let's just, on the question principle, I think it's a holding for two basic reasons. One is the chief is the master of his own opinion, and under his reasoning, he makes it an essential element of his reasoning. It may be the dissent says he gets it backwards. You're supposed to do the statutory construction to avoid the constitutional issue. He does the constitutional issue to set up the statutory question, but that may be a criticism of his opinion, but his opinion is, if this were a mandate, it would be unconstitutional. Therefore, I must adopt a countertextual construction of the statute in order to save it. And he is quite explicit. He says, I would not have adopted this somewhat implausible reading of the statute were it not for my view that the mandate, qua mandate, would be unconstitutional. So under his own reasoning, the constitutional part of it is an essential element of his bottom line. The other sort of more technical point is, I think it matters which theory you use to uphold this. Just think of one of the arguments we made on these tax points, both on the constitutional level and on the Anti-Injunction Act issue. There's a set of people who are subject to the mandate but not the penalty. And that was one reason why we said it has to be a mandate. If it were just a tax, there'd be no explanation for separate exemptions. People subject to the mandate but not the penalty, on our view, they have a legal obligation to buy health insurance, and there's just no enforcement mechanism. On the chief's view, those people, when they do not buy health insurance, are behaving lawfully. And so it makes a legal difference. And, I did the Anti-Injunction Act part of the argument on the first day, and all of these issues were sort of vetted in that context. And I tried to make these points as best I could, and got lots of emails from people I knew and people I didn't know who heard the argument. One of them was completely out of the blue from someone who was in one of those categories. I think it was an American Indian, and they are within the group subject to the mandate but not the penalty, writing me this unsolicited email sort of thanking me for making the point that they're law-abiding citizens, and even if there's no enforcement mechanism, it matters to them. If they're under a legal obligation, they're going to follow it just because they're law-abiding citizens, even if there's no penalty attached to it. So the tax theory has a different substantive reach. That group of people is no longer acting unlawfully when they choose not to have health insurance.
You mentioned a little bit earlier how the lack of the limiting principle for the interstate commerce clause is one of the arguments you made. I was just curious whether or not you thought a similar argument would apply to the holding that actually justified along the taxing clause, in the sense that if the government's able to mandate the purchase of cars or broccoli or whatever, if that's not the reasoning, then why could the same argument not be made that now the government's capable of taxing you for not purchasing a car, or taxing you for doing any number of non-activities?
Yeah. So that's an argument we could have made. I talked about this direct tax clause issue. It is true, under the chief's opinion, the tax works not only for health insurance, but cars and mortgages and broccoli. You can now be taxed for not purchasing any good or service, which is why I think the tax holdings effectively undoes the Commerce Clause holding. We really didn't focus on this issue too much in the briefing, because the argument that this was not a tax was so strong to us. It seemed like any court willing to so twist the statute to turn it into a tax would not then be willing to say, oh my goodness, but it's a direct tax. I'm going to strike, I think it's a tax, but I'm going to strike it down as a direct tax. So the best evidence of how weak the government thought its tax argument was it was like pages 50 to 55 of the 55-page brief. So we had our principal argument on tax was no tax, and then within that sort of minor argument was the minor sub-piece that, by the way, if it's a tax, it's a direct tax. And that's the part of the argument where we could have made this slippery slope argument that you adverted to, but it's kind of 3 layers down the analytical chain, and we never really got to it in quite those terms.
I could just say one thing. I add to it the holding on spending as regards, of course, the states. It's another strange reversal, given history, that a spending condition, right, a condition upon states for receipt of federal funds, would be found to be improper. It's usually, we've been backwards of that for a very long time. So taxation now, as a means of avoiding Commerce Clause problems with federal legislative overreach, maybe it's on the table. Similarly, challenges to conditions upon federal funds, which had, in the context of funding for every form of Section 5 enactment under the Equal Protection, under the 14th Amendment, Congress had undertaken, those are now kind of in question. Because even quite, we could call it coercive, federal funding programs had been very sort of deferentially upheld. There's a new direction over there that cuts in a different way. The one thing that I will say, I think, though, and this speaks to both the two questions, that makes the Commerce Clause ruling a very, very strong decision, is that it has precisely, Justice Roberts' opinion, has precisely shifted, if it sticks, the conversation about limited federal legislative powers to tax and spend, away from the commerce question in a way. And I think there's been a really solid trajectory of limitation upon congressional attempts to use the Commerce Clause all the way up through Gonzalez. And I think sort of moving the conversation away from, well, what is economic in nature? And what counts as a fungible good? I think that there's a way that, at least for a certain kind of new federalist interstate commerce clause, that's productive to keep it where it's at and leave it on the shelf for a while.
Just say a couple words about the spending clause holding, which I didn't get to in my opening remarks. My take on it is sort of like my take on the Commerce Clause holding. There is what seems to be a powerful new holding, and the chief gives that with one hand and then takes it away with the other, which is his remedial holding. So he's analyzing the spending clause problem, and he says, gee, this looks very problematic. There's a huge amount of money involved, so no state could possibly turn down what amounts to 10% of their whole budget. There's a huge amount of strings that come with taking the money that regulate the states in areas where the federal government has no direct regulatory authority. And then there is this kind of leveraging. The chief conceives of new Medicaid and old Medicaid as separate programs. So there's this leveraging problem that if you don't take the money and the strings for new Medicaid, you lose all your money for old Medicaid. And you put all that together, and he says this is a gun to the head. And the best example of that was the hypothetical, Justice Alito's hypothetical in the oral argument, which is suppose Congress did a block grant equal to the entire amount of a state's education budget and said, here, state, you can take this money, but if you do, here are your rules on teacher tenure, and here are the rules on what you have to teach in the class, and how long your school day has to be, on and on and on, and all of a sudden the federal government is micromanaging local education. Well, the chief says that's no good, but then when he gets to the question of remedy, he says the remedy that fixes this problem is eliminating the leveraging from new Medicaid to old Medicaid. So all of the money and all of the strings for new Medicaid, which by itself is completely coercive, he thinks is fine. So I think in the future, Congress can have pretty much any program it wants so long as it structures it as something that looks like a single program with its own set of strings. So I think this one is more unclear about what's going to happen, but my best guess is the spending clause holding is not going to have a lot of bite going forward for that reason.
My understanding of Chief Justice Roberts' opinion is that it limited Congress's ability to use the taxing power to compel people to commerce by, for example, saying that it must be a reasonable alternative to pay the tax rather than for a particular service. So I have two questions. First, what are the limitations the Chief Justice put on the ability of Congress to use the taxing power to compel people to purchase a service? And second, if Congress attempts to raise the penalty to try and force more people to buy health insurance, couldn't there be a subsequent challenge that the new higher penalty is basically too much coercion of the taxing power, and therefore the Supreme Court would be involved in micromanaging the exact level of
Right.
would actually be?
He left that open. It's sort of I know it when I see it standing. At some point, the amount may become high enough that the now tax becomes sufficiently coercive to be called a penalty. But, and you're right, that leaves open the theoretical possibility that if they raise the tax, someone could bring a challenge and say we've crossed that point. I don't think it has much bite. Just, I talked about these cases where the level of the tax, so-called tax, is incredibly high, and the intent of Congress is incredibly obvious in being focused on, it's a regulatory intent rather than a revenue-raising intent, like the marijuana tax. And they just say, they draw a formal line. They say, if it's structured as an exaction on lawful activity, as opposed to a prohibition and a penalty for violation, it's a tax, and we're not going to second guess it because the amount is high, and so, punitive effect. And we're not going to second guess it based on motive, looking at, does Congress care more about regulating or raising revenue? You have to go back to I believe it's 1911, to find the last time the court was willing to take a tax and recharacterize it as a penalty based on either the amount or the intent of the Congress that enacted it. So it's a theoretical possibility, but I find it very unlikely that this or any other court is going to start down that road.
Do you think, is there any chance that it's more than theoretical, since just only so far as that we just saw them reconvert a penalty into a tax? Right? I mean, that is certainly what Roberts does.
Yeah, but on avoidance grounds, I suppose, there's still the basic distinction between tax and penalty in place, which is if the exaction is imposed for violation of some other provision of law, it's a penalty. If it's imposed on lawful activity to support the government, it's a tax. He's now called this tax, however bizarrely, and then there's this jurisprudence that once you're on the tax side of the line, neither the amount of the tax nor the regulatory intent of Congress seem to matter very much. So I don't see it as that likely.
Well, and the only reason I asked that is because I found the entire opinion unlikely, and I was surprised by so many parts of it, including the question of, with all of these, what rationale, if any, are the lower courts going to be able to stitch together among the multiple opinions? We know what the outcomes are, for sure, on the questions. But on what rationale was this spending provision a problem? Exactly. On what rationale exactly is compulsion into commerce not regulation, right? And on what rationale exactly do we say, I see a tax before me, right? But what exactly is the underlying thought? And I think that is what the lawyers are going to have to figure out.
Professor, I was wondering, concerning your religious liberty questions or arguments, it's hard for me to see how, by preventing, let's say Hobby Lobby refuses to give subsidies to its employees so that they can go out and buy contraception. It's hard for me to see, one, how that is a violation of that particular employee's freedom to sin, as you called it. And secondly, even if it is a violation, I'm wondering there who the actor is. Is it the state that's violating that employee, or is it Hobby Lobby?
Well, it couldn't be Hobby Lobby, right? Because our free exercise rights are held only in the government. No, the issue there would be that the exemption itself, right, and as appended to regulations, that exemption is an offense to free exercise. That's the question I'm asking. And I want to be clear. No one is suggesting there be direct subsidies to employees to purchase any form of health care. It's saying that the general policy, the insurer, the provider is chosen if it's not a self-insuring entity. The policy chosen and the provider chosen has to have those services available. And the only reason I didn't stress that is that this is where the argument is to say, how close does the relationship have to be between the owner or shareholder or whomever involved in the corporation? How close does the connection have to be between their provision of insurance and an individual's accessing these services or technologies? So the first question I was asking was whether that, even however close or attenuated it is, whether we can say that's properly an infringement upon a corporation's exercise. The courts so far have been asking and said, especially under the statutory claim, does this count as a substantial imposition upon their free exercise? Now, maybe it is offensive to their free exercise, but is it sufficiently offensive to meet the doctrinal test? On your question about Hobby Lobby, I hate saying that name over and over. It just sounds funny to me. But on the question with Hobby Lobby, it's not a concern that they are violating another's free exercise. And it's not the freedom to sin that I'm suggesting. But rather, by providing an exemption through the federal government to any of these entities, there's a way in which, I guess I wonder if that doesn't create, it wouldn't be a substantial one, I don't think, but create an imposition on the free exercise precisely not to access those technologies if a person chose not to, or to access it, and again, to lapse and suffer the realities of that. What I mean to say is that is the imposition at all, the handing of certain decision-making about coverage to others than individual supplicants, right? Is that possibly offensive to free exercise? In the same way, asking you to buy a plan, not to buy, Plan B, to buy an insurance plan that allows them for a doctor down the line for one of their employees to provide this material. Well, is that substantial or is it too attenuated? And I think we can ask similar questions. I don't think they're winners doctrinally, but as far as constitutional politics and culture, I think they're pretty central. You want to say something?
The exemption is the government not regulating in the case of the lobby and employee.
Not requiring, but allows, right.
I understand the argument that if they are not doing that because of a religious preference to that employer, you could work up an establishment clause argument. I'm just having trouble seeing how the government staying out of that employment relationship one way or the other could give rise to a free exercise problem.
Well, only insofar as, and again, this is where the religion clauses and the equal protection clause, frequently get paired off in terms of differentiations of treatment. For, say, a corporation, a family business that is self-insured, right, that they don't take out an external policy, they do it, they insure it themselves. And let's say, okay, they are not then going to be required to have a policy that directly subsidizes and provides for reproductive technologies or procedures. But they are, at least under regulations of federal, going to have some sort of separate, there's going to have to be some sort of separate additional insurance plan for those employees if they choose and want to access contraception, for them to be able to engage with those separate plans that can't then be tied to or blamed or sort of placed on the employer. Those various differential steps and requirements and separations, I'm just saying that it seems to me that there's a way in which that does require particular steps, particular actions and exertions of energy for you to exercise your religious choice. And that's because of a decision made by the federal government.
Questions from Mark? All right, thank you very much. Thank you all for coming. If anybody feels